Good afternoon to you. Thank you so much for joining us here on Nationwide at 5 this Friday afternoon. It's Friday the 13th. You know, if you're superstitious, they say that's, kind of spooky. Yeah? But
Are you?
I know everybody's God bless, so we don't fear those things. I'm Ricardo Brooks.
My name is Sanjay Lewis. How are you, Ricardo?
All right, Bugs
Yeah,
and
well.
Dana still not give me the curry chicken and the ackee and
Oh, you,
calm pork yet. But I'm
oh,
still,
you still on that?
yeah,
Okay. All
they
right.
promise me they're not giving me, so, I go have them up feet, see me.
Oh, boy. Anyways, listeners, it's cover story time. And for the cover story, we'll be looking at the Data Protection Act and its use by some government bodies to block certain ATI requests. And Nationwide News recently submitted an access to information ATI request seeking clarification on how much is being paid in salaries and benefits to the acting director of public prosecutions, Claudette Thompson, and her immediate predecessor, Paula Llewellyn. But the request has been met with a wall of silence. The Public Service Commission has cited the Data Protection Act as its reason for declining to provide details of the salary arrangement for the two senior prosecutors since Ms. Llewellyn stepped aside. Dana Davey has more.
The Data Protection Act was passed in Parliament in 2020 and became effective December 2023. The regulations serve as a guideline for the lawful handling of personal data and the protection of information to safeguard the rights and privacy of individuals. The Access to Information Act of 2002 grants citizens and other persons with the legal right to obtain access to an official government document which would otherwise be inaccessible. Our news center submitted an ATI request seeking answers from the Services Commission regarding the salary arrangements for Acting Director of Public Prosecutions Claudette Thompson and her immediate predecessor Paula Llewellyn. In a written response to our news center, Human Resource Information and Development Officer at the Commission, Jacqueline Bell Rowe, says the Data Protection Act prevents the disclosure of the arrangements in place regarding the payment of salaries and benefits to both Ms. Llewellyn and Ms. Thompson. She specifically cited the second schedule of the Act. That section bars the revealing of data processed for the purposes of considering a person's suitability for judicial office. The Commission is also relying on a section of the Act which bars the disclosure of data relied on for management forecasting, especially where that disclosure would be likely to prejudice any other activity. The Commission has not clarified what activities it believes would be prejudiced by revealing if and how much Paula Llewellyn was being paid while she remained out of office and how much her replacement is being paid. It's not the first time the Data Protection Act has been used to block public access to information of national importance. The Act was cited recently when the Tax Administration of Jamaica declined media queries regarding the owners of properties it had spent millions to lease but had yet to occupy. The Office of the Information Commissioner has stressed that the Data Protection Act cannot be used to frustrate transparency. The Act establishes the Information Commissioner as the country's data and information regulator. Dana Davey for Nationwide at 5.
Thank you, Dana. So this afternoon, we want to look at the scope of the Data Protection Act and what exactly it covers. For that discussion, we're joined by Deputy Information Commissioner David Gray. Mr. Gray, good afternoon. Welcome to Nationwide at 5.
Good afternoon. Good afternoon to your listeners.
Thank you so much for joining us. So the Information Commissioner says that the Act cannot be used to frustrate transparency. Yet in at least two instances now, we're seeing public entities using it as a sort of coverall to deny what on its face would be basic information that's being requested. Help our listeners to understand the scope of this Act.
Well, firstly, I am not in a position to say that the public entities are using it to frustrate what may be simple information that is being required. Mm-hmm. Because before we get to that point, we first have to understand that the Data Protection Act seeks to protect the privacy of data subject rights. And in so doing, all data controllers are required to process data in keeping with the standards under the legislation, as well as upholding the rights of the data subject and others. Now, in observing the right, and we will agree that there is no absolute right.
Right.
The law affords certain exemptions, and the exemptions under the Act are applicable in specific instances. Now, the information to which you speak of, I will have to make it abundantly clear that we are not seized of that information, and we do not have the facts surrounding it. And as a result, as an office, I could not give a comment on whether or not the public entity has utilized the legislation to its fullest and in keeping with it. So I am not in a position to say whether or not it has been applied in its correct sense or its incorrect sense. Because as an office, we do not have the facts.
Fair, and that's fair. So let me help. Let's look at the second schedule specifically, because that is what has been cited, right?
But again,
No, I'm not going to ask you to comment on the specific instance, because I understand you don't have that information. But what I want you to help our listeners to understand is how the second schedule was intended to operate. It speaks to miscellaneous exemptions, confidential references, the Jamaica Defence Force, judicial appointments, public service employment and ministerial appointments, and management forecasts. So if you could help us understand how this schedule was intended to operate.
All right, well, firstly, before you get to the schedule, the section of the Act that grounds the second schedule is Section 42. And it sets out that the matters in the second schedule shall be exempt from the provisions of this Act to the extent specified in that schedule. Right? So it's exempt from the provisions of this Act. Right? So what it's implying is, if it is that the personal data or information is to be given, you have to apply the exemptions as afforded to it.
All right. So when you use that term, Mr. Gray, personal data, what constitutes personal data? Because my listeners would think I'm a taxpayer, I pay public servants, their salary, surely, and how much they're being paid couldn't constitute personal data?
Well, before you get to that, personal data is defined under the Act.
What's the definition?
And it says, means information, however stored, relating to a living individual or an individual who has been deceased for less than 30 years. And that information can be used, that information or that information alone can identify that data subject.
Let me ask it another way then. Let me ask it another way. Would you agree then that the expectation of privacy for entities or individuals entering into government contracts or those working in government would be less, because government contracts, those working in government, it requires a level of openness for transparency and public accountability?
As what our information commissioner would have said previously, it is not intended to frustrate transparency. But you also have to balance, as all legislative provisions would insist, you have to balance it with what the law affords it. So, yes, one could say that the information that is being asked is freely to be given. But you have to now balance that by looking at your legislation to see if the legislation has put any restrictions on how to proceed.
And when the Office of the Information Commissioner, and I'm sure you've assessed this by now, when you look at that balance, do you think what you found is that there's a fair balance struck between the need to know and access to information and what the Data Protection Act is seeking to protect?
As a public officer who is entrusted with regulating a piece of legislation, I don't really issue a comment on how it is to be applied or how persons perceive it to be applied. I deal with the facts as stated in the statute and applied as per the statute. So I wouldn't be the most appropriate person to give a definitive statement to you in relation to that question to which you are asking.
So am I understanding you correctly then, Mr. Gray, that even where you may think that the balance is, unfair, you're saying that you understand your job as only to apply it without regard for that consideration?
My personal view would not be applicable in that case. I am looking purely, and I'm speaking both as a regulator and as an attorney, to apply the law.
Right. And so my question is, has the office come to a position on that? Or you're saying you will not take a position as an office?
I wouldn't be the most appropriate person to alter the policy as stated in the law.
We have with us the Deputy Information Commissioner David Gray, trying to understand the scope of the Data Protection Act and how it applies to access to information requests. Mr. Gray, earlier you defined how the Act categorizes or defines, rather, what is data.
Personal data.
Personal data. Okay, just remind us of that definition again, please.
Means information, however stored, relating to a living individual or an individual who has been deceased for less than 30 years, who can be identified from that information alone or from that information and other information in the possession of or likely to come into the possession of the data controller, and it includes any expression of opinion about that opinion and any indication of the intentions of the data controller or any other person in respect of that individual. That is the full definition as per the Act.
No, I know we would have, here in Jamaica, tried to get very close to the international standard as it relates to data protection. What justifies such a sweeping definition?
Again, the Act, as you know, would have gone through a legislative process. It would have gone through a joint select committee where the provisions would have been examined by a joint select committee of the Parliament, and the Parliament would have agreed on these terms, which would then be enshrined in the legislation. So again, the legislation is what has been approved as policy by our Parliament.
Mm-hmm. But go ahead, Sanjay.
There seems, though, to be some confusion as it relates to that very section 2 of the Act, because that is what most of these government entities are utilizing to deny requests under the Access to Information Act. Is it that your office have been approached by any of these entities to provide some clarity as to how they should provide information under this Access to Information Act?
Several state entities and private sector entities have sought clarity in relation to how the Act is to be applied, and we have freely given that information.
What has been the guidance that you provided?
Let me finish. Now, you have to remember that it's a case-by-case basis, and it would be in keeping with the specific question asked. So, as the initial treatise by the Commissioner, it is not to be used to frustrate transparency. Mm-hmm. Right? But you now have to be guided by the specific question and how that specific question may be answered in relation to the statute.
But Mr. Gray, is that approach sustainable though? If it is that the office is going to constantly have to field case by case specific queries and questions, is that something that you can over the long term keep up with?
Or why not just provide a broad-based approach to the government entities so that they can respond when the access to information request is sent by various entities?
As again, you see, there is no general answer to any legal question. One has to look specifically at what is being asked. So there is a general rubric. Does it fall within any exemptions? And what information may be available, which will guide you as the regulator, as the legal officer in an entity, as a legal firm who may be called upon to give advice, to indicate to their data controller or other person who may ask the question, to indicate to them that in giving your answer, this is applicable. Because remember, while you deal with the matter of transparency, there are protections in relation to certain privacy matters.
Fair. But on the operational side, though, having to field the requests on an individual case-by-case basis, is that something the office is prepared to do over the long term? Is that sustainable?
That's a part of the functions of the commission itself.
Okay.
To provide that information to everyone that may approach your office, Mr. Gray?
Multiple persons can write to the office, and the office may have to and will have to field the questions as they are asked.
And you don't think that it's unsustainable?
We may have to issue guidance notes to assist, and guidance notes have been issued thus far in relation to the matter of registration. So over time, guidance notes may be developed as in other jurisdictions. Remember, our act is very new.
And just help me, Mr. Gray, those guidance notes now would be of a more general nature?
Would be of a more general nature because there may be specific things that are asked which you will not be able to utilize a general description to respond to.
Okay. In terms of how long you usually take to assist in terms of guidance when you get these responses or requests rather, on average, about how long do you take to respond?
Well, it depends on the quantum of research which may be necessary, but we do try to respond at least within 30 days.
Okay. And as you just said, this is a new act. Your office is a new office, and obviously there's some amount of building out that has to happen. How far along are you in terms of building out the office?
Well, we're at an advanced stage. We're going through the process of registration now. Registration of data controllers.
Okay.
Which is one of the big steps that we have to take in keeping with this legislation.
Yeah.
And given that there is a gray area as it relates to the provision of information through the Access to Information Act, do you think it's necessary, especially to get information about government contracts, which many times media entities, private individuals will try to get that information? Do you think that there needs to be guidance, a broad-based guidance sent to government entities to allow for the process and allow for us to get that information?
Again, we have started from an assumption that there is a hindrance to the giving of information.
There is. There is a hindrance because, and we have seen examples. Nationwide has an example. The Gleaner gave an example. But we're not speaking about those particulars, which is why I asked a broad question. So I'm not assuming the facts are there.
No, but what I'm saying is each case will have to be looked at on its merits. And in looking at it on its merits, we'll have to look at how any specific provision of the legislation may impact the answer.
Okay. Let me ask the question this way then, Mr. Gray. Surely in assessing your new act and the implementation, you would have considered how it intersects with the Access to Information Act, yes?
And that is correct.
Right.
But remember now, this would have been what went through the legislative process. I appreciate that. But we know that when legislation is passed, sometimes there may be need for revisions. And as the regulator, I imagine you're going to have an outsized role in terms of recommending where you think it needs to be revised, if you think so.
So what I wanted to find out was, having looked at where these two pieces of legislation intersect, have you found any instances that you think you may need to refer back to the policymakers to say this requires more attention?
Well, the policymakers went a little further than that, so that it's not only reliant on the office as the regulator. Section 77 of the Act was written in that this Act shall be reviewed every 5 years from the earliest date appointed. So while we will be making recommendations in relation to the provisions of the Act, the journalistic profession and all other entities also have ample opportunity to make their recommendation.
Right, and I appreciate that.
And if it is the considered view from the general public and stakeholders is that the Act is not assisting in the quest to achieve the Access to Information Act and its provisions, then let us suggest the amendments, let us go through the legislative process, and the Act would be reviewed, and at the end of that process, there may be additional provisions that are put in which may make certain things much more straightforward and assist the various public.
Considering that the implementation has been delayed or was delayed, how does that affect the review period? Does that push
No. It says from the earliest day appointed. The earliest day that was appointed in the Act was 2021. So we are already gone 3-4 years, almost 3.5 years into the provisions of the Act as it now exists.
So exempting some people from having to follow through, as we saw, does not affect the appointed date, is what you're saying?
There are exemptions under the Act which may or may not be applicable or have been applied, which may be which may, when it is reviewed, be found to be correct or incorrect, as I don't have the facts.
Right.
Those provisions can come up for review in the process as I outlined before.
Yes.
And may be changed by the policymaker.
Okay. Well, Mr. Gray, I'll certainly be passing on to you our request for you to have a look at our specific questions to the Public Service Commission and their cited response, so you can offer us further guidance on our request.
Well, we would certainly look at it, and in so doing, we will see how best to issue our response.
And we appreciate that. Thank you so much for your time. Really appreciate it.
All right. Have a very good afternoon.
You too, Mr. Gray. Thank you.
Thank you. The very same to you.
That's David Gray, Deputy Information Commissioner in the Office of the Information Commissioner. I suspect that this is going to be a challenge going forward.
Yeah.
It really seems like they're citing it as a blanket objection. I mean, I submitted, I think probably 10 questions or 8 questions, Sanjay. And every single one of those questions, Schedule 2 was cited as barring a response. And I was asking basic things. The salary of the DPP is already known. It's not a secret. I simply wanted to know whether the DPP is being paid her salary and whether the acting DPP is being paid a part thereof, and also what is the status of the DPP. On what basis did they appoint an acting DPP?
Is public, which should be public information.
One would think so.
And we would hope.
Yeah. So I will definitely follow up with Mr. Gray. See if we can get
agree
any
with you,
further
though,
clarity.
Ricardo, that Section 2 of the Act is broad.
The schedule, yes. And the second schedule, yes.
The second schedule, I beg your pardon, which is why I asked him, why not provide guidance to the different government departments so that they're clear as how to respond when these requests are sent to them. I don't see what is so hard in that to do, to provide that general response. I can understand case-by-case based requests that may be sent to them for further clarification.
Yeah.
But it would prevent the number of requests that would be sent to them on a daily basis.
I extend some grace because obviously it's a new office and they have to set it up. And then, of course, once I get that guidance from Mr. Gray, then the next step now is to go to the ATI tribunal. And from reporting elsewhere, we know that that tribunal is not currently constituted. So that's another problem with this matter of access to information, which is very important. And I would hope the information minister would move swiftly to ensure that those vacancies are filled, because people deserve to know, yeah?
Yep.